much for joining us today for the launch of the State of the System report and database. I am Ayushi Sharma, Senior Resident Fellow Crime and Punishment at Vidhi Centre for Legal Policy. Before we begin, we would like to take a moment to express our deepest condolences to the families of the victims of the tragic terrorist attack in Pahalgam. Our thoughts and prayers are with all those affected. I would request everyone to observe 30 seconds of silence, please. To please stand up and observe silence. Thank you so much. As we gather here today to discuss the important issue of impact of overcriminalization on state, citizens, and businesses, I would request everyone to pause for a second and think about this. If you have jumped a traffic light today, or spoken on phone while driving a motor vehicle, if you have failed to file your property tax on time, or disturbed an animal in a zoo, you have committed a crime and can all possibly go to jail. In fact, there are 5,333 crimes you can go to jail for. So this is not an anecdotal problem. It is vast in scale and deeper in impact. At Vidhi, we have been trying to understand this problem for a while now. Since 2015, we have been studying different aspects of the Indian criminal justice system, starting with how the NDPS Act 1985 was implemented in Punjab and Mumbai, how the system dealt with crimes against women, and how criminal law was the primary tool used during the COVID-19 pandemic. The more we studied the system, the clearer it became that criminal law was being used as a one-size-fits-all solution for deeply complex social, health, and governance issues. This led us to a very fundamental question. How much are we criminalizing? What is the scale and extent of crime and punishment in India? 3 years later, we are happy to present the State of the System database, a report, and a platform where all of this research comes together. To release the website and report, we are honored today to be joined by 3 very distinguished guests who shaped the way law, governance, and public policy work in India. We have with us today Justice V. Ramasubramanian, Chairperson of the National Human Rights Commission of India and former judge of the Supreme Court. His judicial career is marked by significant contributions towards upholding the cause of justice, from furthering environmental protections to upholding the validity of circumstantial evidence against public officers. We have next with us Mr. Sidharth Luthra, Senior Advocate, Supreme Court, and former Additional Solicitor General. Mr. Luthra has contributed to some of India's most important cases involving criminal and constitutional law, business laws, and white-collar crimes. His continuous engagement with both criminal defense and prosecution provides him with a unique perspective on how the scale and impact of criminalization, how huge the scale is in India. Next, we have Dr. Shamika Ravi, member of the Economic Advisory Council to the Prime Minister. Previously, Dr. Ravi was Director of Research at Brookings Institute and Vice President Economic Policy at ORF. An eminent economist, Dr. Ravi's work on development, finance, and welfare has helped shape India's economic policy making in critical ways. We are deeply grateful to have all 3 of them here today to launch the State of the System and to share the insights on role of criminal law in shaping governance in India. I would now like to invite Justice Subramanian, Mr. Luthra, and Dr. Ravi to please come near the stage to unveil the website with a click of the mouse.
Delayed filing your tax return? Or jumped a red light in a rush? Or did you give a feeding bottle to a friend who couldn't breastfeed? I have news for you. You might be a criminal. In India, criminal law is woven into our daily lives. It is often unnoticed, snatching routine acts into its system. They're scattered across thousands of provisions, buried in complex language, often beyond its domain. Wishing to protect, mostly ready to punish. How do we follow rules when they are far too confusing? How do we untangle this maze when we do not know where it begins? Where do we start? What do we change? We don't have all the answers, but we do have the tools to find them. Introducing the State of the System, a first of its kind digital repository that maps all criminal offenses in central laws. 370 laws are now in one place. It identifies which actions or omissions are punishable by law and also documents the punishments for these crimes. There are 5,333 that can land you in jail. Only 8, on the other hand, provide for community service. There's so much more beneath the surface waiting for a closer look. Filter and choose the laws you care about. Together, let's ask the right questions. Help reshape the state of our system. Click and start your search now.
Thank you so much. I would now like to invite Dr. Orgho Sen Gupta, founder and research director, and also the crime and punishment team along with the panelists to please launch the report. Thank you so much. I would now like to invite my colleague, Naveed Mahmood Ahmed, lead crime and punishment, to share some of the key findings from the state of the system.
Thank you, Ayushi, for laying the context for a deeper dive into the state of the system now. Thank you all for coming this evening and being a part of this important day for us as we conclude this research exercise of 3 years now with the launch of this database and the report. And as Ayushi mentioned, the work essentially began around 10 years ago. And since then, we've been trying to understand how the criminal justice system works for the citizens of this country. Our learnings from Punjab, from Mumbai, from Sikkim, in Delhi, were really framing the problem for us sharply, that criminal law was being used as a tool for day-to-day governance and not necessarily for actions and omissions that really threaten the core of this country. And we found that in Punjab, addicts were sent to jail. In Mumbai, drug users from the streets of Mumbai were being arrested and prosecuted and sentenced on the same day. We found that in 7 districts in Delhi, 50,000 people were arrested for minor COVID violations. And the problem was also elucidating for us that there is a deep-seated mistrust between the state and the system and the citizens. And this policewala then, of course, was becoming the first and the most visible part of the state in its interaction with the citizen. What it was also telling us was that we were relying on a system that was already crumbling, a system with 3.5 crore criminal cases pending, with an overburdened and understaffed courts and police, with an overcrowded prisons. We were struggling with the system itself, but we were expecting too much from this system. So the problem was there for us, but when we wanted to zoom out and see what is the scope and scale of criminalization in the country, we really didn't have a frame of reference. We didn't have a database, a comprehensive a repository of all crimes in India, and that is where our exercise began 3 years ago in 2022. And 3 years later now, today, of course, we have the state of the system. What does it do now? What is that the state of the system tells us? We analyzed 882 union laws that are currently in force. 370 of these laws have criminal provisions. That is about 42% of our laws criminalize actions and omissions, collectively 7,305 crimes. But that's not it. There are 69 laws with over 20 crimes, there are 28 laws with over 50 crimes, and there are 5 laws with over 200 crimes. Any guesses what these 5 laws are? BNS perhaps might be a good guess. The Bharatiya Nyaya Sanhita, of course, is the primary criminal law of the country. But the other 4 laws have nothing to do with the criminal justice system. It is the NDMC Act, the DMC Act, the Companies Act, and the Merchant Shipping Act. These laws criminalize each of these laws criminalize over 200 actions and omissions, many of which can lead to a jail term. But that is not just these 5 laws. In fact, across the database, we realize the trend that 25% of the crimes, of the 7,305 crimes, are in the core criminal justice laws. The BNS, the Explosive Substances Act, the Arms Act, the POCSOs, the NDPSs, and the Unlawful Activities Prevention Act. 75% of these crimes were in laws that had nothing to do with criminal justice. These are laws that govern our day-to-day living. These are laws that govern how we carry out our businesses. These are laws that govern inland and shipping and inland navigation, 10 laws with 539 crimes. The 3 municipal legislations here in Delhi, 3 laws with 462 crimes, laws that govern transportation and infrastructure, 16 laws with 316 crimes. Even public health legislations, 20 laws with over 200 crimes. But what do these laws criminalize? And Ayushi gave some very interesting examples. If we failed to give our dogs sufficient exercise, we can end up in jail. If we fail to file our property taxes on time, we can end up in jail. If we give a feeding bottle to a mother who cannot breastfeed, we can go to jail for 3 years. If we fail to maintain books of account, if we fail to give notice of a treasure valued at ₹10, there is a 3-year jail term assigned to it. And there are dozens and dozens of such examples that we can give. But that is not it. As students of law, we would understand that criminal law is supposed to be precise, it is supposed to be specific in clearly defining the actions and omissions that are criminalized. But there are 112 laws that don't do it, that have provisions that criminalize unlisted, unspecified actions and omissions. 112 laws that have this general contravention provision, some of which we may be aware of these provisions which say that any non-compliance with any provision of the Act, the regulations, or the rules made thereunder. We tried to map the Factories Act, and it had around 150 compliances. So this one provision was subsuming 150 compliances. And if we do even 1/3 of these compliance mapping across these 370 laws, the data goes up from 7,300 to 20,000. So there is enough criminal law in this country to send us all to jail. But is it necessary? Is it proportionate? Is it efficient? And is it effective? Is something that we really need to ask ourselves. But that's not it. The state of the system also gives us a glimpse of how we punish. Unfortunately, we punish the same way we used to punish a couple of centuries ago. 301 crimes attract the death penalty. The rarest of the rare case, doctrine clearly doesn't seem to be applying in our prescription of punishment at the stage of lawmaking. 433 crimes attract the life imprisonment, 5,333 crimes attract the jail terms, and only 8 crimes attract the community service. But how are these punishments prescribed in law? As we can see, there is a consistent over-reliance on jail terms and long-form custodial sentences within the range of 2 years to 7 years. But how are these prescribed? Is there a method? How do we ascertain what crime should attract which punishment, what term of punishment? Is there a method to it? If there was, this would not be the case. Rioting under the BNS attracts a 2-year jail term, while as willfully giving a false statement under the Births, Deaths and Marriages Registration Act gets you a 3-year jail term. It's for us to see which one of the two is a more serious offense. Similarly, the offense of marrying under the age of 21 years for a bridegroom and 18 years for a bride under the Hindu Marriage Act attracts a 2-year jail term. Under the Foreign Marriage Act attracts a 15-day jail term. It's the same offense treated very differently across two legislations. That's not it. I referred to the omnibus provisions, the 112 laws that have these provisions that criminalize unlisted actions and omissions. How does it impact the prescription of punishment? Let's take the example of the Mental Health Care Act of 2017. The Mental Health Care Act of 2017 has only one criminal provision. This one criminal provision is the omnibus clause, which says any non-compliance with any provision of the law, the rules, or the regulations made thereunder. Now, as some of us may know, it's a very comprehensive law trying to address a very important issue. But how does it punish and how does it criminalize? Failing to maintain records and fulfill reporting obligations under the law is a crime under the omnibus provision. But so is performing a brain surgery without consent of the patient and the board. And both these crimes are punished with 6 months of imprisonment. Perhaps there is merit to distinguish between the two crimes, one being a mere procedural non-compliance and the other perhaps threatening an individual's life. Similarly, there are 252 crimes which relate to failing to furnish documents, statements, and returns across 117 central laws. How are these punished? Under the Hotel Receipts Tax Act of 1980, the punishment for this crime is 7 years of rigorous imprisonment. Under the Trade Unions Act, it's ₹5, a fine of ₹5. Why is this one offense that essentially is a procedural impropriety or a regulation that the government wants to ensure that people comply with is treated so differently across two different laws? There are certainly many, many other things that we can delve into. Why are certain offenses attracting fines while the others don't? Why in some offenses fines are predefined while in others they are not defined? Why are some offenses attracting rigorous imprisonment or imprisonment with hard labor and other offenses don't? There is enough beneath the surface, and I really hope that the state of the system adds some value to our investigation, to our understanding of what is the scope and extent of criminalization in the country and how India punishes. And we have, in fact, recommended in our attempt to recommend the way forward, we have identified certain principles for decriminalization as well as principles for criminal lawmaking going forward. We have also identified certain pre-legislative impact assessments that can help us decide whether criminalization is the most efficient way to achieve the objective of the law or not. But I think these are second-order questions. The fundamental question that we have here is how we as a community see crime and punishment, what we as a society deem a crime worthy of punishment in the country. And I think that is where the first step needs to be taken. Most of our understanding, most of our perception about criminalization, the utility of the criminal justice system, our expectations from the criminal justice system are based on certain specific instances, certain cases, a particular kind of narrative. We hope to bring some nuance to that narrative and provide information for a more informed understanding of the scale of criminalization in the country and our expectation from the criminal justice system. This database is now available on crimeandpunishment.in for all of you to access, engage with, and interact with to truly understand how we as a country should go forward, reimagining crime and punishment for a modern 21st century India. I will close with that, and I would request Dr. Orgo Sen Gupta to take us forward with the discussion.
Thank you very much, Naveed, for that presentation. I think that presentation demonstrates a very salient truth of our criminal justice system. That you said that there are 7,305 crimes, but only 24% of those are crimes that ordinarily people would think of as crimes. So when we have a dastardly terror attack like the one we've had in Pahalgam yesterday, the fact is that that is not the majority of what our system considers crime. That is only 20%. So state capacity also to deal with crimes gets distributed from the really serious ones where we need enforcement to things like not giving an infant, giving a feeding bottle to a mother who can't breastfeed, or walking your pet dog without a leash. So I think there are some really serious questions here, though the examples, some of them may be facetious. So we've got a illustrious panel to discuss this. So I want, for the opening remarks, I want to start with Mr. Sidharth Luthra. Mr. Luthra has seen the criminal justice system from up close for 4 decades now. And so you've seen the data. Little more than 3 decades, but okay, we can do the math later. But Mr. Luthra has seen the criminal justice system from up close and has a really good vantage point. And as he told me, has also done his doctoral work, master's thesis in criminology on decriminalization many aeons ago. So Mr. Luthra, I'd ask you to start with your views on decriminalization and the criminal justice system in about 10 minutes or so. Sure. I only say that because we want a good discussion at the end. So.
The problem about being a lawyer is you like to address standing up always. Criminal law is all pervasive. It touches you from birth till death. How many of you have heard of the Registration of Births and Deaths Act? Anybody heard of it? There's a punishing section there. Be it laws relating to land, consumer affairs, environment, marriage, divorce, there is no part of our life that the criminal law does not touch, and that is a very serious issue for a country. I have often railed against this obsessive criminalization in this nation. I'm glad Vidhi has done a great job, and I'm so happy to be here. I can't tell you, because this is something which I've spoken about more often than not, and the fact that we do not audit our criminal laws. We do not revisit our laws. And what do? We penalize, criminalize all the time, because that is our response to any stimulus. So if there's a public outcry, there is, if I may say so, social media outcry and electronic media outcry, perhaps not necessarily wise, perhaps not necessarily a thinking outcry. The response has been to criminalize. And I say this from the perspective, having appeared for the state in the Nirbhay case. I saw how the 2013 amendments came in. I'm not going to talk about the substantive side, but on the procedural side, we are battling with that nightmare. And I'm going to tell you of a personal incident for a moment. There is a case called Anokhi Lal 2019, which I argued, because the amendment said a trial must be conducted in 2 months. Now, the trial was conducted in 13 days, that a death penalty given. Eventually, the person's conviction was quashed by the Supreme Court in 2019. Sadly and happily, in the sense, by me relying on a judgment called Bashira of 1968 on the very same point argued by my late father. Eventually, after another round of litigation, the man has an acquittal because the DNA evidence has been thrown out. So this is the problem, amongst the problems that pervades our criminal justice system. On a lighter note, we talk about decriminalization of cannabis. I must tell you how cannabis entered the 1985 Act. Marijuana, bhang, cannabis is part of our culture. It's part of our cultural practices. It was never meant to be criminalized, and now the government is trying to at least ease it for medicinal use. But 2 problems. The Western nations wanted it criminalized because for them it was a problem, and they wanted a greater dependence on manufactured drugs to treat people. And then our legislators at the time, in 1985 when the act came in, could not understand the difference between opioids and cannabinoids. Opium and cannabis, उनको भांग और हफीम में फर्क नहीं आया. And if you see the debates, it is shocking. There's a book written for which I wrote a foreword by Khagesh Gautam. You may want to revisit it. Now let me come to the issues. We have the Ramanujan Committee in 2014 set up to see the laws. The numbers have already been placed by you. And I'm told that the numbers you've stated are absolutely, the numbers here are absolutely accurate, because my understanding also was about 6,000 laws. Now, the first thing we must understand is, why is it that the Indian state is reluctant to decriminalize? Why is it that we turn to the courts? Whether it be same-sex relationships, whether it be 494, that is bigamy, why is it that we're looking at the courts? Unfortunately, the reality is that we have not had the political will to reimagine our criminal law. We had a golden opportunity when we brought in the BNS, the BNSS, and the BSA, but eventually, and without causing offense to those who do not enjoy a drink, it is old wine in a new bottle. What have we done with the BNS? We said sedition is bad, but then we brought in another avatar. We brought in organized crime, which was a state offense, into this. We brought in, what is it called, hate crime into it. But the point is, this is covered by murder. If anybody had cared to look at a 2013 judgment, I'm forgetting what it's called, is by Justice B.S. Chauhan. I'd argued it for the state when we said we have adequate laws. So the point today is, we have to understand where have we gone. Please tell me, why should securities laws be criminalized? 2010, I was addressing a talk, 9 or 10, in SEBI to all the law officers of SEBI. And they told me candidly, we have criminal law provisions, we have stringent criminal law provisions, but we don't want to apply them because the system works so slowly. It is easier to put a heavy penalty and proceed. And this is the bane of our existence, because we have decided to criminalize everything. I'm a amicus in that matter relating to negotiable instruments cases. We thought we did a great thing by making sure that checks would be honored. We've actually brought the destruction of the criminal justice system, because those numbers are unmanageable. In a case called Makwana, Makwana, Mangaldas, Tulsidas, they said at that time, 35 lakh cases arising out of check bouncing all over India. The court tries to deal with it. There is a PIL, which is expeditious trial. I'm appearing as amicus in that. It has been listed the last few years a couple of times. I'm trying to get a fresh listing now, but the problem is it was sent to a committee. The committee came out with some suggestions, but the problem is larger because we don't have the numbers, we don't have the human resources, we're trying with digital resources, but the numbers are just sheer. The only light we see at the end of the tunnel is nothing to do with the system. The light is because you are giving up on checks. It's not all RTGS or bank transfers. So once electronic payments have become, that is going to be the solution. You know, the perspective that we've seen with the union government is, with the Jan Vishwas Act, which dealt with 42 laws, various sectors, agricultural, environment, media, publication, and they said, let's have monetary penalties. I think it's a great idea. But out of these 42 acts, you're having 23 acts which deal with the ease of doing business, life, or institutional structures. The other issue is, what about the rest of the body of the laws you've heard about? When will we revisit them? It's a step forward, but nowhere. And I am told that it's a fragment of what we're dealing with. Because don't forget, what you've heard and read today is, we're talking about central legislations. What about state legislations? Having more than a certain amount of alcohol at home, watering your garden with normal water, tap water, you get a penalty for that. But these are all state offenses. Try cutting a branch of a tree in Delhi. The branch is hitting your electric pole and you fear there is going to be a fire. Till you get permission from horticultural and forest, you cannot touch that branch. I'm not saying trees should not be protected, but it's a cognizable offense. So we have to also look at not just the central laws, the state laws. On the other hand, while Parliament has sought to touch these 23 acts, we have laws such as surrogacy, regulation, offense, Muslim women protection of rights of marriage, offense, foreign contribution, offense, and rather seriously so. I hope you're not getting foreign contribution, Orga. We are members of the Oxford-Cambridge Society. I tried in my 3 years as president to unravel that. I could not unravel an account which is stuck for 50,000 rupees. We had a problem. Industrial Relations Code, Waqf Amendment Act, Companies Act, offense. And if all of that is not enough, we have the PMLA. So I'm not going to go much deeper, but we must keep one thing in mind. The criminal sanction is society's response to things which are to be prescribed of the highest kind. To trivialize the criminal law, to make it visit every small act, is abhorrent to a society which believes in the rule of law, to a nation which wants to live by its constitution and the fundamental rights. We have to understand, we are a citizen-centric, after all, legislators and legislatures speak our voice. But by criminalizing conduct, are they speaking a voice in consonance with the fundamental rights? Therefore, I will leave you with one thought. We must examine how our laws are touching the lives of ordinary citizens, not just the few who manage to reach court or brief lawyers. I deal with a fair amount of legal aid cases, and I must tell you, and Justice Ramasubramanian has much vaster experience than anybody in this room. Lawyers deal with 5 cases, they deal with 50 a day. He will tell you more, or his experience will tell you the way criminal law touches lives and for whom, people for whom there is no relief once it's touched your life. So the first, I'll just leave you with 4 thoughts. We must look at alternative regulatory mechanisms. Make laws work, regulate, penalty if necessary, take away criminal liability, take away offenses. One of the most disturbing things, and I must say, is that we brought in community service, we didn't expand it to a greater reach. We've only talked about sentence bargaining. We've not talked about offense bargaining. In the US, you go and you say, all right, it's a murder case, we'll bargain to culpable homicide or rash and negligent act, please reduce my sentence. The case is out of the system. We must bring in digital platforms, but not at the sake of bringing in our own biases. Otherwise, a gentleman like me, if I can call myself a gentleman, with fading hairlines, may be prosecuted because somebody doesn't like people with fading hairlines, or somebody wears spectacles. So the biases have to be kept out. And lastly, audit your legislations for the impact on citizens. Don't go by the data we have, which is available in the public domain. It does not pass muster. It does not examine or consider the human element. Thank you very much.
Thank you very much, Mr. Luthra. I think that was an impassioned plea for decriminalization, and coming from one of our foremost criminal lawyers, as in this is certainly music to our ears. And thank you very much for sticking to time. Justice Ramasubramanian will know how difficult it is to get senior advocates to stick to time. So thank you very much, sir, for doing that. We don't want this to be a discussion only amongst lawyers and judges. So I'm particularly delighted that Dr. Shamika Ravi is here with us today, who brings in a lens of an economist to what is essentially a problem of a publicly funded, taxpayer-funded system, which is a criminal justice system. So I know Dr. Ravi has a short presentation. So Dr. Ravi, to your opening remarks, please. We'll try and get that presentation on the screen in a moment.
Thank you, Argo. Good evening, everyone. It is indeed This is not a normal situation for me, where I'm usually speaking either to bureaucrats or to fellow economists. So it is particularly a wonderful occasion for me to bring to you a lens which I think Vidhi is trying to bring to this problem at large, which is an empirical approach to the problem. You know, there is in economics a concept called opportunity cost. And we're beginning to, through a group of scholars across the country and some beyond, put a lens of what is the opportunity cost to not just having bad laws, which is what the purview of today's State of the State report, but also largely in terms of what happens when the judicial system doesn't really deliver what is a very basic right to citizens. Now, you've heard people talk about quality of living. And you know, one of the measures which globally we are signatories to, which is the Sustainable Development Goals. And you know what SDG 1 is? It's eradication of extreme poverty. And you will all be delighted to know, but perhaps you already know, that in the last 12 years, if you look at a measure like the Rangarajan poverty line, which is not a simple food shortage, which is what Tendulkar poverty line was, but this is more conservative because it talks about access to health and education, having rental, money, having conveyance money, etc. So it's a rich conservative metric. Even by that metric, which by the way is higher than the World Bank's measure of extreme poverty, India has eradicated poverty from 29.5 just 12 years ago to today where it stands at 3.9%. What I'm trying to tell you is that after 60 years of Garibi Hatao, the country has actually managed to get a handle on some of the deeper, long-running problems like extreme poverty. You look at any of the Sustainable Development Goals, maternal mortality, infant mortality, neonatal deaths, you look at quality of life by very many other metrics, India is making tremendous progress, except for one measure, which is contract enforcement. Despite multitude of efforts, at least, well, Jan Vishwas happens to be one, but despite, and my heart sank a little bit when I found out that your master's thesis, I don't know how long back that was, about decriminalizing, but it is a little bit worrisome that something so fundamental is not coming at us, or we're not trying to handle it with the kind of urgency which perhaps it deserves. It is affecting quality of life of an average citizen. And today, all I want to do is compliment Argo and Vidhi's approach to telling you how powerful data can be when you look at some of these problems and you're trying to make a compelling argument for why we need to throw all our weights behind not just internally making our laws more consistent, but also rational, which is what this report eventually is about. For instance, in the larger report, which I did read, a 2 rupee fine. Now I'm wondering, the least one could do is make it inflation adjusted. Who carries 2 rupees? How do you put 2 rupees together? A lot of these are old, they're anachronistic, and they can be fixed relatively quickly. But there are many others which will require deeper scholarship, right? Let me start off by just giving you a sense of the district court's data which is now available. Not because the government has made it available or the courts have made it available, but because there are scholars, such as this group today here, that scrape the data. And this data is for 2014 to 18. And we are just looking at what is the average time taken for a criminal case to actually get a judgment in a district court. The first, murder. And I'm trying to tell you, when the states of this India, there is no one metric. It actually hides a fair bit because each state has its own set of problems when it comes to either the laws themselves or the judicial capacity to execute some of this. On an average, only half of murder cases get a judgment within a year. But just look at the systematic difference across states. And at the bottom, you have Delhi, Odisha, West Bengal, Kerala. These are not the poorest states. In fact, these are some of the richer states. Delhi is perhaps the richest state in the country. So it's not just about resource, it's also about the justice system, and the way it deals with some of these problems. If you look at rapes, again, you find the same set of 9 or 10 states, which have barely 20% of cases that do get a judgment within a year. kidnapping and abduction. I'm only showing you criminal cases. Again, at the bottom you have Kerala, you have Delhi, rich states. Robbery and dacoity. So the problem is no longer only at the national level, which is what this report is about. There are big variations in terms of the judicial capacity to execute and to actually carry out. Look at cheating and dishonesty. In ease of doing business, this is a very critical aspect. In fact, you'll be surprised to know, in the bilateral investment treaties that we are entering now, India is uniquely in a position where counterparties are now putting delays in contract enforcement as one of the risk factors. Earlier you heard of political risks, right? Because there would be changes in government, there would be changes in law. Now, the way the delays are getting institutionalized and the country is having to pay a price in terms of costlier investment, delayed investments, and so on. Unlawful assembly rioting. So this data, you can just continue to look at it. And it jumps at you that there are systematic variations, that there is a national problem. And I think this report has made a remarkable first significant step towards addressing it. But we really have to get into the weeds. And data is a very powerful medium to tell that story. The empirical approach which Vidhi has taken, in fact, I do want to not just applaud, but I want to encourage you to look at some of the data systems that are becoming available now, Argo. Because you can get into the details of the specific laws that we caricature and make fun of, but how many lives have they actually impacted? How many people have been imprisoned because of laughable laws and criminal laws? Now, Jan Vishwas, when we started talking about it, including Jan Vishwas 2.0, we started with much loftier ambitions. And somehow, through the system, it really winds down to a handful less than 100. It's laughable. So I'm here to encourage the team and to say that join forces. There are other researchers across the country, particularly economists. In fact, the group whose data I showed you today, these are economists across the world who have scraped e-courts, district court data, and they've put it together. And you can use some of this. But our effort will also be to ask administrators and push the judicial system to make more and more data available so that fine-tuning and improving and internally rationalizing a lot of these laws are made possible. So ease of doing business is a larger basket, and we tend to think of it only as an economic factor, but it really does affect the quality of life. Because very many aspects of running business, and there are huge state-wise variations. The same investments, in fact, a case that deals with land in Bihar takes on an average 15 years. Are you really surprised Bihar struggles when it comes to getting investments? So economic lives are intertwined with a lot of these bad laws, and we are having to pay a real cost, and that's what the opportunity cost of it is. In fact, the more you study the data, the more you realize that Vikasit Bharat, in terms of the ambition that we have, and ministry after ministry, or different parts of the economy, is fine-tuning and bringing to the table how they contribute to this. I think one of the biggest or the most significant impediments to that is this, the problem that we are talking about today. Our justice system, which is not just bad laws, but the low capacity which delays and costs tremendous losses, is a very important factor that is going to keep us away from that dream and that collective dream. So congratulations on this wonderful report, and I do look forward to working with you guys on the next round. Thank you.
Thank you very much, Shamika. As I've always said, that the criminal justice system is too important to be left to lawyers, and so we always believe in a multidisciplinary and multi-stakeholder approach. And thanks very much, Shamika, for being here, and we will certainly take you up on that offer of taking this forward, because there is a long way to go. I turn now to Justice Ramasubramanian. Justice Ramasubramanian, as Mr. Luthra said, has seen this as a judge. Now he sees this as chairperson of the National Human Rights Commission. And today, in this gathering, he's like our Bhishma Pitamaha. So he always has an insight which no one else has in my long years of knowing him. So Justice Ramasubramanian, over to you for your opening remarks. You've heard all the data, you've heard all the speakers. Now we want to hear you.
Is working. I thought if it is not working, I will make this one more offense. See, Mr. Luthra said, as a lawyer, he has been accustomed to speaking while standing. As a judge, I have been accustomed to speaking while sitting. Therefore, I will continue to do what I am good at. At the outset, I should congratulate the team, Ravi, that is team, which has done an excellent work. I felt little, ashamed because 2 years ago, a National Law School University conferred me a doctorate degree for doing nothing. In fact, it is this kind of research that actually deserves doctorate degrees. But this is the irony of life. People who work will not get rewards. People who don't work, they get rewards, whether it be lawyers or judges. I am just going to give you only 1 or 2 points because I always try to make it little light. You have heard the economist's perspective and the lawyer's perspective. If I had continued to be a judge, I would have said judgment reserved and walked away. And maybe if there is a next meeting and if I am invited, I would have pronounced judgment on the next occasion. But that is not to be done. I'll start with a story. 2 friends, childhood friends, met after a very long time, about 20 years. They were in the same flight. They were very happy to see each other after 20 years. One of them asked, "Arey, where were you? What are you doing?" This man said, "What to tell you? I got caught in a criminal case. I was arrested. I was prosecuted. I spent 10 years in jail. I got released yesterday. I am returning back." Then he asked the other man, "What are you doing?" That man said, "I am worse off than you. You committed a crime. One inspector was after you. You went to jail. Spent 10 years, you have returned. I started a business. You committed a crime. One inspector was one inspector was after you. I started a business. 20 inspectors came after me. There was an income tax inspector, customs inspector, central excise inspector, inspector of factories, inspector of ESI, inspector of Provident Fund, inspector under the Minimum Wages Act, inspector under the Payment of Wages Act, inspector under the Income Tax Act. He listed 20 inspectors. And he said, it is a much worse crime, heinous crime, to start a business in this country than to commit a crime under the Indian Penal Code. We talk about this ease of doing business. In a fit of rage, one lawyer told me in Hyderabad, "What, my lord, what is the ease of doing business? It is not ease of doing business, it is actually the disease of doing business." That was the kind of frustration that people have been pushed to. But what is the reality? We all talk about statistics, but we miss the core issue that lies at the bottom of this whole thing. As a society, our psyche is tuned to convert all civil cases into criminal cases. As a lawyer, I have seen people who have lent money, who could not get back their money, used to come to me and tell me, "Sir, file a police case." Whenever I used to tell them that it's a civil case, it's not a criminal case, they will tell me, no, sir, 406, 420, somehow you convert this into a criminal case so that I get my money back. Therefore, despite all the pitfalls, you must admit this reality. despite all the pitfalls of the system of administration of criminal justice, the faith of the common man in this criminal justice system was much more than the administration of civil justice. They had more faith in criminal justice. We condemn police. We condemn the criminal justice system. But the common man wanted to go to the police to recover his money rather than going to a civil court to do this. Why is this happening? This is one thing that we have to think about. Mr. Luthra talked about 138 cases. In fact, as a lawyer, I had a client who had enormous number of 138 cases. He told me one day, sir, I have become very friendly with the magistrate because he was appearing almost in 10 to 20 cases every day before the same magistrate. So familiarity not only breeds contempt, familiarity also breeds something else. So he told me that, sir, whenever the magistrate wanted to take leave, he will request me, please don't come to court tomorrow. So that is the kind of understanding that, see, when 131 check bouncing was made an offense, they never thought that what could be its ultimate outcome. You know what was the ultimate outcome? People who jumped upon this opportunity to convert a civil case into a criminal case, they had to face the music. In fact, if the complainant did not appear, the cases got dismissed. That client of mine, he told me, sir, in most of the cases I have won. I asked him how. You issued a check. It bounced for funds being insufficient. How did you escape? He said, sir, most of the time out of frustration, complainants did not turn up. Therefore, the cases got dismissed. So, instead of punishing the person who committed a conduct, let us not put it as a criminal offense. Instead of punishing the person who is responsible for the state of affairs, the system punished the complainant himself for a second time. So this, but unfortunately, there was a demand. Our psyche demands that all civil cases get turned into criminal cases. You take, for instance, Motor Vehicles Act cases, rash and negligent driving. I have seen, as a lawyer, that in most of the cases, even where the drivers were not at fault, they pleaded guilty because pleading guilty and paying a fine, though you were not guilty, was a much easier option, much better option than conducting a case. We have made the whole process more agonizing than the end result. If you have to go through a motion for about 3 years, setting aside everything, and ultimately get acquittal or your conviction is upheld, it doesn't really help you. Recently, I've had the case of one of my childhood friends whose wife lost nearly 1.17 crores to this digital arrest scam. Ultimately, by the time he woke up and lodged a police complaint, through 738 transactions, the money had been sent to several places which could not be traced. The police was able to stop only the last 10 lakhs being, withdrawn. For getting this 10 lakhs back, this man had to run to court. Out of frustration, he told me one day, I think I will better lose this 10 lakhs also. It doesn't really compensate me for the loss of that 1.17 crores. Therefore, we have a system where a lot of things happen. And it is not just the lawyers, it is not just the litigants, it is not just the system or the judges who are responsible. There is something greater. And what is that cause? I think that is another area of research which I would request all of you to read. With this, I'll close my opening remarks. Thank you.
Thank you very much, Justice Ramasubramanian, for that deep insight. I think, as you've rightly said, that there is, despite all the ridiculing that we do of the inefficiencies of the criminal justice system, there is a sense that we only take action seriously when something can land us in jail. There is this sense that exists. And so there are many questions that we have, but I'm only going to, in this brief panel, so that we can also have questions from the audience, I'm only going to focus on the way forward. And we've seen the data, we've heard from the panelists, but I want to focus a little bit on where do we go from here. So, Shamika, I'll start with you. You've seen all of you, a common thread in all you were saying, in what all of you were saying is how India is such a difficult place to do business. And this is something that we are facing in terms of our negotiations on BITs. And some of our data shows that 252 crimes across 117 laws criminalize the failure to furnish documents on time. Now, surely this is something that someone ordinarily should not go to prison for. But what's the way forward? This is something that very few reasonable people will disagree. But still this has remained on the books despite many reasonable people sitting in government as bureaucrats for a very long period of time. What do you think it takes to move this ahead?
I think we'll go at the onset, technology is surprisingly used very little when it comes to a lot of these cases. Given that, you know, whether it is the medical records, whether these are financial records, the registration records, increasingly there is such a massive digitization effort that has happened in almost every aspect of doing business. Furnishing data or documents ought not to be such a difficult task, right? But I think the way our system is organized and the culture around seeing physical copies is unnecessary. So I think, you know, in Jan Vishwas, I'm hoping that 2.0 will take care of a lot of these extremely simple to handle means of sharing and the use of technology which can sweepingly take care of a lot of these issues. Right? Now, certain kinds of things need gazetted officers and so on and so forth. But even there, I think just making it self-attested, you know, again, these are all technological fixes. So I think while we have seen improvements in terms of, you know, the larger ease of doing business, right from registering to winding up and financing, etc., there is very minimal use that we are seeing when it comes to contract enforcement. And I think making things available, not only is it then more transparent, but I'm guessing the judgment also then is relatively more transparent. So the delays that everyone spoke about here, a lot of it because sufficient documentation not being available, you know, again, very quick to fix. So I'm hoping that Jan Vishwas 2.0 will tackle these sort of issues, and I'm told that they are.
That's right. So Justice Ramasubramanian, I'll take that point to you because your example of the two friends meeting on a flight, the fact is that these kinds of inspections always take the most toll on small businesses. Bigger businesses will have compliance officers and so on to deal with each of these 20 inspectors in whatever way they deal with them. But one reason we find, and this is just a hypothesis, we may be wrong, as to why a lot of these crimes continue to remain on the books is because of the fact that ultimately the people who get most adversely affected are the most marginalized and the vulnerable. So if we were to take even some of these examples, a sweeper being absent from duty for 1 month without notice, he can be put in prison for 3 months. A hawker who is selling goods on a railway carriage is can be imprisoned for up to 3 months. So we see that ultimately the common refrain in India that the rich will get away and it is the poor that will suffer. Do you think that that is one possible reason as to why the number of crimes that we have on our books has gone on increasing and has not been rationalized?
In fact, I have two perspectives to your question. One is, when these petty things were made into offenses, the lawmakers perhaps thought that the fear psychosis that it creates will make people become more compliant with the provisions of law. In fact, the corporates at the top layer, they all comply with these. They have a compliance officer, etc. Why? Because they wouldn't like the CEO or the MD to go and stand in a criminal court. So this fear psychosis has worked well with them. In fact, there is a very interesting saying about this, in olden days, that 397, 398, etc., oppression and mismanagement. They used to say that these are weapons in the armory of the shareholders, which when brandished in terrorum is more potent than when actually used to strike with. Therefore, these were intended to create a fear psychosis so that you become compliant with the law. The top layer became compliant. The bottom layer, it is much easier for them economically to get caught occasionally and face the consequences. The cost of compliance is much higher than the cost of non-compliance and getting caught. This is one perspective. Second perspective is little on the flip side. It is not as though the big businesses, they escape. They pay penalty in the form of something else. That's all.
That's true, and I think that is the elephant in the room, and we all know as in how the criminal justice system operates in this country. But Mr. Luthra, I'll continue on that same thread in terms of the way forward. One of the examples that Naveed gave was of the Mental Health Care Act, where there is only one provision. Now, one provision, if you look at merely in terms of data, as in that's not too many crimes that it may be a misleading number. But as a result of that, what has happened is that if somebody is performing a psychosurgery without consent, then that is imprisoned in exactly the same way as someone not filing their record in relation to what the facility that they are running. Because it is an omnibus offense, it's not laying out what the specific offenses are. So this is a pattern that we see across the board of this kind of omnibus offense. Now, how do you as a lawyer see this kind of offense? Don't you think that something like this is jurisprudentially and practically completely unsound? That the lawmaker is not even laying down what that offense is. Like, how am I as a person who wants to comply with it know that what do I have to comply with? It says anything under this act. What is anything under this act? How do you see this kind of provision, which is really one of the main ways in which this 5,333 number has been composed, sir?
So I'll tell you something a little more abhorrent. You're touching the tip of the iceberg. There are statutes which have, other than the specified offenses, an all-encompassing provision which makes breach of a rule, an executive order, or a regulation framed by the executive also punishable. Now that's really shocking. On the one hand, you say it must be law to be prosecuted. You must be prosecuted in accordance with the law, and that law must be parliament-made law or legislature-made law. On the other hand, you've given the executive the power to bring in, to regulate the nature of conduct and then made it punishable under the main act. Of course, it's supposed to be guided legislation or guided regulation. I think I'm going to go to a slightly different topic for a moment, and I'm going to just digress. I think it's time to really have a different revolutionary look at our legislations. The one thing we must understand is there needs to be a fundamental relook. We've always looked at legislation from the perspective, and I say this in light of my previous comment, that the legislature put in a larger framework and the executive was given specific powers to bring in rules, regulations. On the one hand, we talk of technology. All of us are talking about technology and the use of technology. And we're talking about use of development, technological development to ease our lives. But parliament or legislatures do not function at the speed technology develops. So you are possibly going to come to an era again where we will have legislation like the Epidemic Diseases Act, which had 3 provisions and entire executive powers. Now, if you look at that era, you're going to have a situation where the situation today, where we're troubled about one executive provision, one all-encompassing provision, is going to be a lot worse. So that is the era I want us to look at and prepare for, because that is the future of this nation in terms of legislation. We cannot have a situation, and this is my belief, I see in the decades to come, legislation is going to shrink. We have, as lawyers, traditionally thought that legislation provides the framework and the executive powers work within. Perhaps yes, but the executive powers are going to increase. And therefore, the first thing is, we have to relook at extinguishing offenses as far as possible, regulating conduct, if at all, penalizing it by financial penalties. But then don't forget, when you have a financial penalty of 5,000 rupees for a person who's driving a two-wheeler, he can't pay that 5,000 rupees. He has a 1,80,000 or 50,000 two-wheeler. So what will he do? He'll pay the head constable 200 rupees and get away. So there is that incoherence and lack of reality. We often legislate for Delhi, Bombay, Calcutta, Madras. We do not legislate for Bahadurgarh, for Etawah, for small towns from north, south, east and west.
So I think that's a sobering note, that this is not going to happen overnight. I think there is certainly great political will at this point of time to decriminalize offences, both for ease of doing business and ease of living, and that's certainly something that can be welcomed. But there are two notes of caution. One, as Sir is saying, that we have to look at it in terms of the larger picture, where executive power is increasing and Parliament is just reducing in its importance, and also state legislatures by the same token reducing in importance. And as Justice Ramasubramanian rightly said, that in India, culturally, going to jail is still seen as something to be feared, and maybe that element is still there. So Naveed, you've heard everybody speak, as in then they've all in some sense been responding to the data that you put out there. What do you see as the way ahead?
I think the first step really needs to be, as a society, as I said in my presentation also, we really need to ascertain what we as a society deem a crime worthy of punishment. And it can vary from periods to periods, and it can change, evolve over time. But at some point we need to examine, what are we using this police person for? What are we using the criminal justice machinery for? And the first step that we have also in fact proposed in the report is a principled approach to criminal lawmaking. And it is something that has been done before. It is something that exists in India. It is not an alien concept. When courts have reviewed section 377 of the IPC, when they have reviewed provisions on adultery, when they have looked at attempt to suicide, when the Law Commission has reviewed offenses against state, all of these concerns have been taken into consideration, and there is a broad framework. And there is a broad framework that is already present. It is about applying that framework not before the courts when they are ascertaining the constitutional validity of a particular provision, but at the stage of lawmaking. So if we are able to do this at the stage of lawmaking, coupled with some pre-legislative assessments. So whenever there is a ministry that tables a bill that has a criminal provision, we need to do an assessment about how is this going to play out. Do we have enough police people? Do we have enough courts? Do we have prisons? Almost half of the prisons in the country operate at a 170% occupancy today. So what is that we hope this prison to solve things for us? So pre-legislative assessments, a principled approach, both for a forward-looking criminal lawmaking as well as the ongoing decriminalization attempts, will actually go a long way in in addressing some of these issues.
Naveed, just a word of caution. I must tell you this. I really felt it's important to tell you on the data, ma'am, as well as the data you use. When I made a loaded statement that the data is often not accurate, and I'll tell you why. Policing deficiencies or aberrations lead to not only underreporting but misreporting. That's a chronic problem which we are not picking up in the data. And that's the problem with the data, because we don't even realize what kind of crime is happening. On a second note, we brought in, and now we have legislatively brought in preliminary inquiries. It was brought in by the various police rules and regulations and cognizable offenses that matrimonial matters, cheating cases, economic crime, corruption cases, there will be inquiries. Now, corruption, of course, cases stand on a different footing. But as Sir said, in cases of commercial disputes, the police departments have for long become places where you resolve matters by payment of consideration through this inquiry system. In Lalita Kumari, I remember we had, the initial period was that these inquiries will go on 7 to 14 days, 15 days. Thereafter for Delhi police, I appeared and got a modification for that. It became 6 weeks to, 15 days to 6 weeks. But these inquiries go on for months together. And they are actually a means of, and today if you scratch the surface, that whole body of crime is either not being reported or it's not crime at all. And I mean, I don't want to give you anecdotal information, but I'll just share one thing with you. An airline in this country which did very well would not have taken off, but for a complaint I had to draft one day because they had two pilots. One decided not to join. They poached them from another airline, and they said, look, we need something done. So we had to, I said, look, this doesn't make an offense. They said, do something, the rest you leave to us, and they managed. And the planes took off.
This is exact. Most of these conduct, but people tend to criminalize every civil conduct into criminal conduct.
Exactly.
That, see, correct. See, I have occupied this post for the past 4 months. We get about 300 complaints every day, totaling to about 1,18,000 complaints a year. Type of complaints that we receive by the National Human Rights Commission. Somebody says, my property has been I sold my property to so-and-so, he promised to pay so much, he did not pay so much, I wanted to lodge a police complaint, police has taken money from the other side, not registering a complaint. This is neither a police complaint, nor a human rights violation. When I say that, they ask me, no, Supreme Court has said, property is a human right. Right to property is a human right. Therefore, it is a human right. Therefore, even if the laws decriminalize much of this conduct, people tend to criminalize.
That's right. And I think that this just shows that this is a long journey and this is a societal journey. It's not just something that we can do, change the law tomorrow, because as you rightly said, the lawmakers are reflecting what they think society believes. And society believes, like Mr. Luthra's client there, that please file some criminal case and then we will get our remedy. Yeah, Shamika.
See, although no data is perfect, right? But in the absence of data, what you're basically either going to continue to make theoretical arguments, or if you actually realize that even systematically, if you account for different kinds of measurement biases, the whole idea of showing you these 6 kinds of criminal cases across states is to tell you there is something systematically that jumps out at you, which is that here are your worst 10 states when it comes to people, ordinary citizens' access to judicial system. Do they get a judgment, any judgment? They could go to high courts later within a year. Now, I'll tell you a lot of policy making, a lot of refinement, the kind of changes we are talking about. I think, of course, principle-based, full marks to that. Who can argue against that? But when we realize what is the severity, how many people are really suffering on account of this, what is really the delay, what is the real cost, and a lot of these things actually the data does pick out. In fact, the one area where we are not doing any surveys are in terms of ordinary citizens' access and real cost of accessing the judicial system, right? We have incredible survey data when it comes to amenities, when it comes to any aspect of governance. In fact, we're putting tremendous pressure on the state, right? When it comes to vacancies of different kinds, public health, we have so little data. And like I said, whatever little we have is because scholars like yourselves have gone out and scraped and done that bit of effort, which ideally should be available.
Dr. Ravi, I just want to add, and I think the point was slightly distinct. The question is, when you pick up data, you pick up that data which you're calling for, which is recorded data at a point. So you're not picking up data which is also, and for a moment, leave what is not recorded. If you start, so I'll give you a simple example. there is every information that comes to a police station is going to be recorded in a general diary. Some will become FIRs, some will become non-cognizable reports, some will become some will not go anywhere and complaints will be filed. Some FIRs will come through the court system, that's all separate. But there are those number of complaints which land up with the police, which are recorded but do not culminate in an FIR because of resolutions or otherwise. Now, the point is, that is a point which we are not looking at. Why is it? I mean, I'm telling you, I've today had to deal for a case for the Andhra Pradesh government where a person who was prosecuting somebody under the SC/ST Act was picked up by the police and the next day made to say, look, I didn't see anything. And 1.5 years later, he was again picked up to withdraw his complaint, and then finally his brother complained, so he's come back and said, actually, I really made that complaint and I'm sticking, and now he's given a statement before the magistrate. So what I'm trying to tell you is that we have to go a little deeper beyond the documentation that is offered to you. And this is a challenge which we always face. And while we tried to, well, judicially it was sought to be done in Lalita Kumari, it's sought to be done in the BNSS. Go to the root, you'll find a lot more, even if you don't get the complete picture, but it'll be a more comprehensive picture.
I think that's absolutely right. Data is necessary, but not sufficient. But in the absence of data, we also see a lot of bad decisions and bad policies being made. I think this is only warming up. This can go on for a while, but I do want to get the audience in. We've got a little bit of time left for a few questions that you might have. Please do raise your hands. There should be a mic that should come around to you. And please do identify yourself and keep your questions short so that we can get 3-4 questions in. Yes, there's a gentleman there in the blue and then a girl in the blue as well. I think the mics are here, if someone can pick them up. And the gentleman in the blue. Yes, so please make this a question and not a comment or an opinion. Please do ask a question. Yes, sir.
Sir, I'm quoting 3 websites, Amar Ujala, Dainik Jagran and Jaipur Dialogue. So they are saying that there's a website called Central Grievance Management System, CGRMS. They can reduce the burden on courts, but they are not functioning, means they are just disposing cases and not giving any solutions. So what's your take on this issue?
The Central Grievance Redressal Management System was a
Central Grievance Redressal System.
Yeah. They are not doing anything. They are just disposing.
No, but the point is that if a person is prosecuted, it is only the court which has got to, give him.
No, just for small cases, they are telling that.
No, petty cases, what happens is they are entitled to pay fines and get out. For instance, footboat travel. It's only mobile courts are there, they pay fines and get out. There are evening courts which were established for the purpose of dealing with these petty offenses. So it is not that system that works, it is the actual courts, whether it is mobile courts or evening courts or the regular courts which deal with them. Otherwise, the cases will not get resolved through a system. The courts use that system. The system by itself will not become a court.
That's right. The girl in front. Yeah, please.
Thank you. I just had a small question. So I was listening to a lot of the anecdotal evidence which was presented, and from my limited experience, I feel that a lot of those instances are private wrongs. So my question was that would you be of the opinion that one of the reasons for the overcriminalization in India is the underdeveloped nature of torts law in this country?
Not really. I think the problem is torts law is now developed through the field of Consumer Protection Act in a big way, and to some extent even through the competition laws. The chronic problem is we have too much reliance on the criminal justice, I'll call it the criminal justice administration, not the system, as my Professor Bakshi always clarifies. We have too much reliance because it gives you a quick fix at times. Is the quick fix a litigant wants? The litigant does not want to go, pay the court fee, wait for years to get a result. And I'm telling you this, I'm going to share another perspective from you. How many of you, the only perspective I've not had is of Justice Bindal and Justice Ramasubramanian, but I've had 3 perspectives in the criminal justice system. I've been a prosecutor, a defense lawyer, and I've been a witness in a criminal case, not a palatable situation. So from that perspective, I tell you, people do, even as a litigant, as a claimant, you don't want to go to the system. Most people say, let's just resolve and let's get out. And that is when some of the clever ones will turn to the inquiry system which exists for economic crimes and use that as a mechanism, to be very blunt, on a percentage basis to recover their dues or settle disputes.
Time for 1 or 2 more questions. Yeah, okay, we'll take them together so that we can, yeah, there's one there. We'll go to that corner and then we'll go back there. Just hold the mic a little closer.
So I have heard the way forward from all of you, and thank you very much for that. I wanted to ask, as I see the problem, is that both the politicians, as the parliament legislatures, they prefer to criminalize. As a society, as Justice Subramanian has pointed out, we want to criminalize it. As a system, because all the participants in the state machinery that benefit from it, they also prefer this because they can go to anyone and everyone and ask for some sort of payment. So where does a common citizen go from this point?
So we'll just take 1 or 2 together so that we can finish in time. Yeah, at the back. Yeah.
Hi, thanks. Thanks for taking questions. My name is Manas. I'm a reporter with Mint. Dr. Ravi mentioned that enforcement of contracts is an important factor when it comes to reining in foreign investments, for example. I just wanted to get your perspective quickly on the idea that foreign investments into India today are also, people also factor in the fact that that enforcement agencies in India, law enforcement agencies in India, like the CBI, like the Enforcement Directorate, are having proactive presence, taking action against businesses and individuals in the country. Do you think that actually also factors in for foreign businesses, and do you think that might have a potential impact if this continues? I think this is important considering India is the fastest growing economy in the world. This might be impacted. What's your take on it?
Thanks. We'll take 1 more. The lady there in the, I think you had your hand up. Yeah. And then we'll take 1 last round. Yeah.
First of all, thank you for the insightful discussion, everybody. So I just want to get some insight on the community service aspect. I think one of the speakers mentioned that. And if we recriminalize the less serious offenses, how will, as a society, can we, the aspect of fear psychosis that Justice Subramanian talked about. So can we actually resolve or try to resolve if we inculcate the community service aspect in resolving it?
So, Justice Ramasubramanian, you want to take the first one and the third one?
No, I will take the first one and the second one. The first one is a very interesting question. His question was, politicians want to criminalize. As a society, we have a psyche to criminalize ordinary conduct. The stakeholders in the system, they are also benefited by criminalizing conduct. In such a situation, where will the common citizen go? That is your question, correct? I want to know who is a common citizen. Common citizen is one who is not a lender, who is not a lender, who is duped by his borrower. Common citizen, if he is one who is a landlord, who has got a very honest tenant, he continues to be a common citizen. The moment he gets into a problem, automatically that common citizen gets into the psyche to convert ordinary conduct into criminal conduct. Therefore, the common citizen you are talking about is a person who by fortuitous circumstances remains outside the legal fold. Therefore, don't talk about common citizen. Insofar as your case, your question is concerned, it's about community service. It's a very good option. In fact, in the Western country, we have laws which prescribe community service. But unfortunately, there is, we live in a world of paradoxes. There are judges, proactive judges in the past, who have prescribed community service as a condition for granting bail, not really as punishment after conviction. Unfortunately, the law is settled that you cannot impose conditions other than what are prescribed by the code. So some of those community service conditions were actually frowned upon by courts. So that is because of the letter of the law. So this is a contradiction in terms, but it's a good suggestion. If most of them are taken out of the purview of criminal law, but then community service is prescribed, I think there will be a lot of improvement.
I just want to add to what sir is saying. What is the purpose behind criminal law and punishment? You know, we begin with the title crime and punishment. The whole idea is, do we want to reform or not? Do we want to rehabilitate? So the mechanism to reform and rehabilitate a majority of the offenders or a large portion of the offenders is either through psychological tools or through rehabilitation, and the means of that rehabilitation, the means to, in a sense, to penance to society and get reintegrated into society is community service, and therefore we need a really serious legislative push for community service, which will be a way forward for a more stable and less conflict-ridden society.
You know, actually I would take that as an empirical question. What is the common man? Because we, impose a certain view of a common man without really having an empirical basis. I think the common man today is far smarter than perhaps, 70 years back when you were thinking of, with limited state capacity, criminalizing very many aspects of business life, let's say, right? Today, I think a simple entrepreneur who wants to do something, if you think of the startup space, younger people and so on, I think they do demand decriminalizing. You know, when you say that politicians, I'm sorry, this is a very casual way to treat the law. An average businessman, you really have to look at the surveys. What a difficult life they have because the laws are very poorly worded, and therefore that gives a lot of leeway not just to the inspectors that can hold him, right, but even the judicial system as such, right, and the delay of course compounds everything. So it's an empirical question what you're asking today, and I think India is primed. We have to bring about these changes that this report talks about, because that is just being it's a timely support that you can give to a nation which aspires to grow, but growth isn't really a theoretical concept. Growth is the changing lifestyles of all of us. Ask your parents and your grandparents. This is a transformed nation, and laws have to adapt. So it's very much a timely question, I think. To your question of enforcement directorate, that's a good political story. It's not an economic story. Are foreign direct investors scared of these? No, of course not. They would be more worried about SEBI and the RBI laws and so on. So again, something we were talking about before the event started. We really need to bring in more economic training into judicial training. I think our lawyers are uniquely badly trained in economics. No, I'm saying this as a very serious statement. Just as much as we're trying to bring in more and more law into economic policy making. I think it's very important to understand laws when you're thinking of better policies and improvements and reforms, etc., because this is a binding constraint. You can't wish away the legal structure and keep talking about, utopian and so on. But similarly, I think in a lot of our legal studies, good understanding of economics and what are the institutions which are likely to deter investment or spur investment, very, very important. And again, counterfactuals are very important. That is the heart of opportunity cost that I talked about. Economics is about incentives. Better laws are those that account for incentives. Thank you.
So we are completely out of time, but we'll take one quick last round if everyone makes their questions quick. Yeah, there's a lady at the back, gentleman at the back, gentleman in front, and you've had your hand up for a while. Yeah. So 4.
Hi, I'm Bhagni from Center for Civil Society.
Very quick. Yeah.
Yeah, based on the conversation we've just had, is prison abolition something we as a country would be open to at some point?
Prison abolition.
Yeah.
Okay, there's a question that is, as a country, are we open to prison abolition? Okay, the gentleman there, just, yeah, Prakasha.
Hi, this is Akasha, I former legal journalist. I wanted to just check something. One of the issues raised here is the, that these laws create so many of these little small kind of offenses, and then they can lead to malicious prosecution of people. But do we think that having, that any sort of move to remove these things and sort of declutter the whole system needs to be accompanied also by having better laws for malicious prosecution, having, should that be part of the process or separate?
Got it. Here in front.
So I really like the pitch of this whole discussion that you decriminalize. But if we decriminalize, the obvious route that is left for the people is the civil law. So is it correct to say that the only way to actually implement decriminalization is to have a very robust civil law, because otherwise we are left with nothing? Thank you.
Got that? Sir. Yeah. Great. So just behind you.
Sir, my name is Sagar. I run a media company. My question is very simple, sir. When you talk of, piling up criminalizations, laws and everything, so when everything comes to a company and a lot of things are coming up, so we have the, mechanism to get it sorted out. And you have just said that regulatory body has to be established, which is very essential. And there can be various mechanisms to, remove all these piling up of the criminalization or whatever.
So could we
is
get
the
to the
subject.
question?
Yeah.
Just we are out of time.
So how far this can intervene in the system? Is it possible, or we will have another sort of state intervention like Pahalgam?
Okay, so we'll just go around from here to the end with whichever questions you want to answer, and last word, Mr. Luthra. No, I think there's a question on prison abolition, 2, law and malicious prosecution.
Yes, well, I am sorry to say my name figures on a report in relation to finding a solution for malicious prosecution. I had little to do with it, but my name is there, so I plead guilty. Having said that, there is no effective law for malicious prosecution in India, and we really need to relook at that. So far as prisons are concerned, not abolition, but there's a need to have an open prison movement. There's a need to have a more open report. We can look at things, though privacy issues may come up, electronic collars so that people can be out on released. They're released in the public, but at the same time their movement is controlled and regulated. So we need a real upheaval to declutter our prisons and ensure that the people in jail are convicts and not under trials.
No, actually you are right. See, if we have a robust system of administration of civil justice, then I think the civil courts function very effectively. But the problem is, I tell you, I am good at converting every solution into a problem. I'll tell you how. All of us want a very effective system of administration of justice. Suppose you have borrowed money. You were not able to repay it. The contract says that on the 91st day after default, your property can be brought to sale without intervention of court. This is one of the best methods of recovery. But on the 91st day, if the amina of the court comes to your house, you go to court and take a stay. What do you tell your lawyer? I am talking about a honest borrower. That honest borrower tells his lawyer, sir, I have borrowed money. I want to repay. Today I don't have money. Buy some time. Is it not? you tell your lawyer, buy some time. Second case, you enter into a contract, taking a place on lease or license. You are there for 3 years, you are well established. Landlord serves a notice, contract says after 30 days notice, you have to vacate. In developed countries, after 30 days, you automatically go out. Here, you have established your business, you have a card, you have an identity. Therefore, when you go to court after receipt of notice from the landlord, what do you tell your lawyer? Sir, I am only a tenant, I have to vacate, but buy me time. So 50% of the litigants who come to civil courts not for ultimate result, but for buying time. You must remember why our courts are clogged with so much of litigation. See, I used to ask this question. People should have lost faith in courts, correct? They should have stopped coming. Why are they coming? Because 50% of the population thinks, see, any institution which renders some service, if it is not rendering the service which is expected of it, that institution will be closed, correct? Why are the courts not closed? Because 50% of the litigants who come to civil courts, they come to civil courts asking for only one type of service, and that type of service is very well rendered by the service provider, namely courts. This is a hard reality. We are not living in an utopian world.
Very true.
Ah.
Even same criminal cases.
Correct. Correct.
We'll take this offline because we've gone over time by about 15 minutes. I'm sure we can go on a lot more, and I'm sorry, I know there were many other hands which we couldn't take, but maybe you can catch them for a minute and ask them your question later.
The session itself could not be completed on time.
That itself.
How can the courts complete cases on time?
That's true. Yeah, despite our fervent attempts to get the senior advocate successfully to finish on time. But ladies and gentlemen, thank you very much for coming. There is as I'll leave you with one statistic that popped out at me when the team did the work, that there are 7,305 actions or omissions for which you can be arrested under a union law. Comparison, the United States, no paragon of criminal justice, 4,500 federal offenses. So we know that we have a lot of rampant criminalization, as in this country. This is just union law. There's much more with states. Our work will certainly continue. But upshot of this session is that things will change if society changes. And if our desire that inko jail bhejna hai, this desire is limited to actions which are truly crimes and not petty disputes, which can be resolved face to face, person to person. So do visit the website. It is a public good for everybody to use, for lawyers, for journalists, for anyone else who's interested. crimeandpunishment.in, do visit the website and do use it and spread the word. And please do give us your feedback. For now, please join me in thanking our panelists and speakers. We have a small token of appreciation, so may I please ask Ashna to give a small token to Justice Ramasubramanian. Ishan to Mr. Sidharth Luthra. It's easier you come from the front. Maybe easier. And Shriyanshi, a small token to Shamika Ravi. And thank you very much, ladies and gentlemen, for coming today. It was a really thought-provoking session, and I hope you will be with us for future Vidhi events. Thank you, and good night.